Supreme Court of the State of New York, County of New York, Criminal Term, the People of the State of New York, Part 59, Indict. Number 71543, 2023 charge against Donald J. Trump, defendant. Before, falsifying business records, first-degree jury trial X100, Center Street, New York, 10013, May 2nd, 2024. Honorable Juan M. Merchant, Justice of the Supreme Court. Appearances. For the People, Alvin Bragg, Jr., ESQ, District Attorney, New York County 1 Hogan Place, New York, 10013 BY, Joshua Steinglass, ESQ, Matthew Colangelo, ESQ, Susan Hoffinger, ESQ. Christopher Conroy, ESQ, Becky Mangold, ESQ, Catherine Ellis, ESQ, Assistant District Attorneys Blanche Law by Todd Blanche, ESQ, Emil Bove, ESQ, Netchley's Law, LLP by Susan Netchley's, ESQ, Stephen Weiss, ESQ, Attorneys for the Defendant Susan Pierce Bates, RPR, CSR, RSA Principal Court Reporter Lori Eisenberg, RPR, CSR Lisa Kremsky Teresa Magnicari, 1804. The Clerk. This is the People of the State of New York against Donald J. Trump, SMZ 71911 of 24. Appearances, starting with the People, please. Mr. Steinglass, for the People, ADA Joshua Steinglass, Susan Hoffinger, Matthew Colangelo, Christopher Conroy, Becky Mangold, and Catherine Ellis. Good morning, everyone. The Court, good morning. Mr. Blanche, good morning, Your Honor. Todd Blanche on behalf of President Donald J. Trump, who is seated to my left. I am joined at counsel's table by Emil Bove, Susan Netchley's, and Stephen Weiss. Good morning. The Court, good morning. Good morning, Mr. Trump. As you know, I asked the jury to come in a little bit later today, at 10 o'clock, so that we could have our hearing on the order to show cause, which is identified as SMZ 71911 of 24. I looked at the exhibits that were provided by both the People and the defense. The People provided 4 exhibits, one for each one of those violations. The defense provided a number of exhibits. I believe it was close to 500 pages in total, and also submitted also 1805 the violations, and explained to me why you believe that it constitutes a violation. Mr. Conroy, sure, Judge. Unless Your Honor prefers it, I think that I will not play each of the video clips or even read the direct language. I will just talk about each of them, and I will let you know which one I am speaking about as I am speaking about it. The Court agree you shouldn't play the video. You can give me the exact language and why you think it is a violation. You should do that. Mr. Conroy, okay. Judge, I just want to start by saying the defendant's complaining that this order restricting his extrajudicial statements in this case was not intended to allow everyone to attack him, but not to allow him to respond, and that's on page 1 of his memo. The order was issued because of the defendant's persistent and escalating rhetoric aimed at participants in this proceeding, and the order was intended to prevent the defendant from attacking witnesses in this case and jurors in the case and others. He has already been found by the court to have violated the order 9 times, and he has done it again 1806 with respect to the first violation I am going to talk about. This is, actually, the second violation on the order to show cause that we handed up. It's Exhibit F in the April 25th affirmation. And I will just start by reading it. Defendant said the following, but this judge said that I can't get away from the trial. He is rushing the trial like crazy. Nobody has ever seen a thing like this. That jury was picked so fast, 95% Democrats, the area is mostly all Democrat, U of it as just a purely Democrat area, is a very unfair situation, that I can tell you. This was just hours before he had a hearing here related to his previous violations. He was on the media, and he used his platform there to criticize the seated jury in this case. There is no inference needed, is not just any jurors, it is these jurors, in this case, sitting right in this room in a few minutes. His contrived justification in his papers is that, well, the media was saying some of what I am saying. That's a little bit like his reposting argument, except weaker. 1807 creates an air of menace that is substantially different from a media report. By talking about the jury at all, he places this process and this proceeding here in jeopardy. That is what the order forbids, and he did it anyway. I will move on to the second violation that we are alleging, and it is actually the fourth in the order to show cause. It's Exhibit H in the affirmation that we filed on the 25th. That statement was made on the morning of the 25th, on his way down here for the hearing at some kind of a press event, I think at 49th and 5th Avenues in Manhattan, and the defendant was out, and there were reporters around who were asking him questions. Think that was all part of the plan. And one of the questions, and I will read now the question, and then the defendant's statement. The question was, what have you thought of David Pecker's testimony so far? When was the last time you spoke to him? The defendant's answer was, he has been very nice. David's been very nice, a nice guy. This is a classic carrot stick. First of all, there is no question that there was 1,808 to be testifying an hour or 2 after the defendant made that statement. As I said the other day, the defendant knows what he is doing. He talks about the testifying witness, says nice things, does it in front of the cameras. To be clear, he was asked other questions about this case and ignored them. This was not just the defendant responding to everything the reporters were asking him. He selectively responded to this question and not others. The one he answered was about the witness who was testifying, was deliberate, and it was calculating. Pecker, be nice that everyone is hearing this. Have a platform, and I will talk about you, so be nice. What the defense counsel described as innocuous statements about Mr. Pecker on page 5 of their memo, anything but. They are deliberate shots across the bow to everyone that may come to this courtroom to tell the truth about the defendant and what he did. Moving on to the third statement that I will talk the order to show cause, and it's Exhibit G in the affirmation that I filed. This is from an interview that the defendant gave 1809 April 23rd, didn't actually air until that evening, and the statement is as follows, well, Michael Cohen is a convicted liar, and he has got no credibility whatsoever. He was the lawyer and you rely on your lawyers, but Michael Cohen was a convicted lawyer. He was a lawyer for many people, not just me, and he got in trouble because of things outside of what he did for me. Largely, it was essentially all because of what he did in terms of the campaign. I don't think there was anything wrong with that, with the charges that they made, but what he did ISIS, he did some pretty bad things, I guess, with banking or whatever. If it was a personal thing to him. David Pecker, I don't know exactly what he's going to be testifying against Boutor about. He will be testifying today. Again, no question this is related to this proceeding. The defendant is talking about two witnesses, one of whom was on the stand at the time in the middle of testimony. It's clearly willful, clearly knowing. The defendant thinks the rules should be different for him. I talked a bit about the impact of 1810 witness, but on other witnesses is an insidious thing. I will talk a little bit more about Michael Cohen in a moment. Moving to the end, again, in that statement he is talking both about Michael Cohen and his credibility, which is a theme here, and then about David Pecker, who is the witness on the stand. Finally, I will move on to the first statement in the order to show cause, which is Exhibit E from the April that was made also on April 22nd, 25th affirmation. Earlier in the day than the statement I just talked about. And I know I said this the other day, that this statement was made right outside of these doors, the doors of this courtroom in the little pen that's set up where he speaks to the gathered media every day. He stood there for almost 9 minutes and he talked about a prospective witness that was going to be in this courtroom at some date in the future, Michael Cohen. What he said was, and it's two different excerpts, but they called the payment to a lawyer a legal expense in the books. They didn't call it construction. They didn't say you were building a building. They called it a payment to a lawyer because, as you know, Cohen is 1811. I am not the only one and wasn't very good in a lot of ways in terms of his representation, but he represented a lot of people. But he puts in an invoice, or whatever, a bill, and they pay, and they call it a legal expense. I got indicted for that. Later the defendant went on, quote, and when are they going to look at all the lines that Cohen did in the last trial? He got caught lying in the last trial. He got caught lying, pure lying, and when are they going to look at that? This and all of these are clearly related to this proceeding. They are clearly willful. The defendant is talking about witnesses and the jury in this case, right here outside the door, all during the trial. This is the most critical time, the time the particularly proceeding needs to be protected, where defendant has demonstrated over time, and recently, his willingness to say and do anything he can to try to infect and disrupt this process. That's what the defendant has tried to do and continues to try to do. We understand the court's concern about Michael Cohen, but in the statements at issue here, the defendant 1812 about things Michael Cohen has said in the weeks and months before defendant's statements at issue here. There is mention of TikToks more recently, and I will talk about the exhibits, the 50-plus exhibits, now 500 pages of documents that were filed with defense papers. But there is nothing to indicate that the defendant saw those statements when they were made. Order has only been in effect for 4 to 5 weeks, not months. Michael Cohen is not a political opponent. Defendant's comments about Michael Cohen relate to issues at the heart of this proceeding and Michael Cohen's participation in the proceeding. They don't relate to political policies or goals. The defendant is doing everything he can of the defendant to make this case and the proceeding about his politics. It's not, it's about his criminal conduct. His statements are corrosive to this proceeding and to the fair administration of justice. As Your Honor knows, we just did this the other day. What we have to prove here is the existence of a lawful order expressing an ongoing mandate, which I submit is very clear here based on the court's previous decision and other litigation on this very issue. 1813, that's what we have just gone through, and we have to show that it is made with knowledge, and it is willful beyond a reasonable doubt. I would remind the court that on Monday, April 23rd, Mr. Blanche in court with the defendant sitting right next to him, said the following about the defendant's knowledge of the order, and this is from the transcript on April 23rd, page 964, line 10 to 15. There is, just to set the record very straight and clear, President Trump does, in fact, know what the gag order allows him to do and not allow him to do, and there was absolutely no willful violation of the gag order in the 10 posts released by the campaign or what the people just discussed. The court, what was the page number on that? Mr. Sorry, that was page 964, April 23rd, lines 10 to 15. The court, thank you. Mr. Again, the existence of a lawful order, I don't think is at issue at all. There has been plenty of litigation on that. The court issued the decision the other day. Based on the comments themselves, the timing, and even for the one comment, the location, I submit that we 1814 willfully and knowingly violated the lawful order of this court on each of the 4 occasions that I have just went through. We are asking the court, again, to impose the maximum $1,000 fine for each of the 4 violations. Because each of these statements was made before the court held the defendant in contempt for violating this order 9 previous times, and because we prefer to minimize disruptions to this proceeding, we are not yet seeking jail, but the court's decision this past Tuesday will inform the approach we take to any future violations. We are happy to answer any questions. Thank you. Court, none at this time. Thank you. Mr. Blanche. Thank you, Your Honor. Mr. Blanche. So, part of my argument this morning does react to the court's order on Tuesday, from April 30th. While we disagree with the court's order, to some context, we are guided this morning in what I am going to say to the court by what the court said to us on Tuesday. First, the purpose of the gag order, Your Honor, is to restrict extrajudicial statements in order to protect the integrity of these proceedings by shielding those 1815 part in these proceedings without concern. And as I will get to in a few minutes, Your Honor, that concept alone is reason enough to deny the 4 that we are here about this morning. And I know that the court has stated repeatedly that the gag order and Your Honor's intention is not to allow unfettered attacks on President Trump, recognizing he is running for president, doing a campaign every day. Part of the campaign takes place outside of this courtroom. Part of the campaign takes place in interviews, meetings with potential voters, whether there is press present and on the campaign trail, and Your Honor said it again in the order on Tuesday. And there is no dispute, I think, among anybody, the court, or the government, that political attacks and responses to political attacks does not violate the gag order. And I disagree with the people. I disagree that the time that we start looking at what President Trump is responding directly to is the day of the gag order. Since President Trump announced his candidacy to run for election this November in 22, almost 2 years ago, there have been multiple and repeated attacks on him from, among other people, Michael Cohen, and folks at 1816 again. To talk, I will get more into this in a minute from our exhibits, Your Honor, to talk not only about these proceedings, and not only about Mr. Cohen's credibility, and not only attacking President Trump's credibility, but also attacking him running for president, the qualities he would bring as a leader of this nation and reflecting on the presidency 4 years ago. The court, if I can make a suggestion, Mr. Blanche. My main concern is the conduct that took place after the gag order was implemented. I looked at the exhibits that you provided. You want to go through some of them, that's fine, but it's 500 pages. Mr. Blanche, I'm not going through all of them, Judge, of course not. The court, just as you know, it's not going to weigh very heavily on my decision if you refer to exhibits a year ago or 2 years ago before the gag order was in place. Mr. Blanche, Your Honor, it is not my intention to do that. We will get to that in a minute. In response to the court's order on Tuesday, and in preparation for our hearing today, we are prepared to 18:17 a.m. referring to today, I believe, our recent exhibits that bear on the 4 charged counts. But, Judge, do think it's appropriate when the court's considering whether there has been a willful violation of the gag order beyond a reasonable doubt, to keep in perspective beyond just the gag order. Your Honor did that in reaching the conclusions. That's what I am talking about today, that's it. The court am telling you what I am going to consider when I make my decision. You can do that. Mr. Blanche, Judge, last weekend, President Trump's rival, President Biden, said in a public forum, he talked about this trial, and he talked about a witness that's going to be in this trial. He mocked President Trump. He said, Donald has had a few tough days lately. You might call it stormy weather. Okay, President Trump can't respond to that in the way that he would want to because of this gag order. Stormy weather, as everyone in the court, where Mr. Blanche, it's one of our exhibits, Your Honor. Stormy weather was an obvious reference to Stormy 1818 the court. You are saying that he can't respond to what President Biden said without saying Stormy Daniels? Mr. Blanche, that's exactly what I am saying. He cannot respond without saying Stormy Daniels, Your Honor, he is not allowed to. The court, no, he is not allowed to refer to a foreseeable witness in the case. He is certainly allowed to respond to something said by President Biden. There is nothing in the gag order that says he can't. Mr. Blanche, Your Honor, I am not saying that he is not allowed to respond to President Biden, but he is limited in what he can say. President Biden is not limited. So, President Biden can make a reference to this trial and to a witness in this trial. President Trump can respond about certain parts of this trial, and, Your Honor, that's just my opening point. That happened this past weekend is to give context to the 4 statements, which is the reason why we are here today. Monday evening, Your Honor, we are also going to hand up to the court and the government shortly exhibits we will offer, and they are Exhibit 61 through 126. 1819 Michael Cohen recently, certain mea culpa podcasts, recent ones, and I don't believe every one since the gag order, but recently, and then certain video transcripts from news programs regarding Mr. Pecker's testimony, the jury composition, and Mr. Cohen himself. And I'm not going to go through all of them. I'm going to highlight a few of them before I offer them up, and I have a thumb drive with all of them. The court, okay. Mr. Steinglass, thank you. Court, is there a reason why this wasn't provided before when you submitted your answering papers? Mr. Blanche, yes. The court, what's that? Mr. Blanche, the additional exhibits are in response, as I mentioned a few minutes ago, to Your Honor's order on Tuesday, because Your Honor made plain in the order recognizing that there would be opportunity, and it may be necessary to allow to remove certain people from the gag order if they didn't need to be protected. That's the reason that we are coming at it late, Your Honor. So I'm going to go in a little bit reverse order. 1820 statements about Mr. Pecker. So what President Trump said, David Pecker, I don't know exactly what he is going to be testifying about, but he will be testifying today. So that was a recording, as the government just said, on April 23rd, for a news show in Philadelphia. Aired about 6 o'clock that evening. That was in response to a question from the interviewer saying, where is your concern level at this point regarding David Pecker's testimony and Michael Cohen, but focusing on David Pecker for now. Where is your concern level? President Trump sidestepped the question. Gave a very factual, truthful answer. It wasn't a warning. It wasn't a commentary on what Mr. Pecker had testified about, and, certainly, it was not a willful violation. I mean, he is just talking, as the court knows from the testimony, about a man that he has known for decades. He is talking about a man who he was friends with for decades. There is no threat in what President Trump said, and we cited 10, there are multiple articles, we cited 10 of them in our papers, news articles that are going into excruciating details about Mr. 1821. So, when you have President Trump in response to a question saying something completely neutral about the witnesses, that's not a willful violation of the gag order, when the intent of the gag order is to make sure that Mr. Pecker comes in here and testifies without fear of what President Trump has said or will say. The court, it's not just about Mr. Pecker. About what all the other witnesses who may come here see. If the witnesses were to see Mr. Trump speaking about Mr. Pecker, or even Mr. Cohen, it affects those witnesses as well. And that's why I understand your concern of Mr. Cohen. I expressed concerns about Mr. Cohen and Ms. Daniels in my decision, and those are valid. I get it. But it's not just about those individuals. It's about what everybody else, the jurors, and all of the other witnesses see Mr. Trump saying or not saying about other witnesses, and that's a concern. That does go to the integrity of the proceedings. Martha Blanche, Your Honor, as applied to this case and this trial and what's happening behind us, that's the reasons why this gag order isn't fair. The court, when you say, behind us, Mr. Blanche, I'm talking about the press and 1822 happening in this courtroom and everything that the witnesses are saying. And, so, every time we whisper to our client, it's live-streamed over all sorts of social media outlets, every word the witnesses say, and so then you have President Trump who is asked a question. Everybody is talking about it. What do you think of his testimony? And he doesn't say, I think he is a liar. He better watch out. He says something, he can't just say, no comment, repeatedly when he is running for president, and I appreciate the court's concern, very much so. And we are reacting to what Your Honor wrote on Tuesday, but it's also appropriate to turn to what's happening with this trial. The court, what's happening in this trial is no surprise to anyone. Meaning, the former president of the United States is on trial. He is the leading candidate for the Republican Party right now. It's not surprising that we have press here. We have press in the overflow room. There are people throughout New York that are interested. Everybody that came into this knew this would happen. We all suspected it. There are no surprises here.